Apna Course. Get smart, get ahead.
The internet issues are slightly more complicated because this may involve operation of international law. International law basically limits a country's authority to exercise jurisdiction to cases which involve the interests or activities of non-residents of that particular country. There are normally three types of jurisdictions which we need to look at. One is the legal jurisdiction, which is a jurisdiction to make a law, to prescribe a law. Second is judicial jurisdiction, which is a jurisdiction to sit in judgment or adjudicate. The third is jurisdiction to enforce, which is the enforcement jurisdiction. So in internet, we have laws of one country trying to influence the citizens of another country, courts of one country deciding about the citizens of another country, and the eternal problem of how to catch hold of an offender because he is in a different police jurisdiction. So internet provides these kind of challenges. Now over a period of time, cases have been tried in different courts, and internet-based jurisdictional issues have led to conflicting judicial decisions. But we can say mostly courts have defended jurisdiction based on whether there is an impact of a web transaction in the geographical location of the court or on the citizen of a particular country. For example, a publication of an article on the issues of a state in a web publication headquartered in a different state. Maybe jurisdiction is assumed in the affected state, though the publication is run from a different state. This is called the effects principle. That is, the website is and its services is having an effect on another jurisdiction. In a famous US case referred to as the Zippo case, the court suggested a sliding scale test to determine whether a website can be considered as passive, active, or interactive, and it suggested that jurisdiction based on the extent of interactivity with the residents of the forum state could be used. The court held that the likelihood that a personal jurisdiction can be constitutionally exercised is directly proportionate to the nature and quality of commercial activity that the entity conducts over the forum residents. Obviously, if it is more interactive, the possibility of jurisdiction is higher. If it is passive, it may be less. This is the idea of that particular case. In 2007, there was something called referred to as Howard case, which actually overturned the Zippo verdict. In this case, the defendant moved to dismiss a proceeding for lack of personal jurisdiction, arguing that its contact with the state in question, Illinois, were insufficient because this particular entity did not have any office or facilities in the state of Illinois, did not transact business there, and owned no property located in that particular state. Further, the company argued that it was not registered to do business in Illinois and all its activities took place in Missouri location, and therefore it cannot be tried in the court at Illinois. Now, responding to this motion, the other party, the plaintiff, argued that the court could exercise general jurisdiction over the defendant due to its continuous and systematic general business contacts in Illinois, to say that there are people in the state of Illinois with whom there was a business contact for this particular company. And in the process, the plaintiff invoked the Zippo sliding scale test and claimed that these contacts arose through the defendant's website, which allowed its visitors to make appointments, fill out surveys, and ask questions. The court found that it lacked personal jurisdiction and it vacated the judgment. And then the plaintiff sought the review with the appellate court, On the appeal also, the court affirmed that perhaps this report test could not apply to this particular case because the court felt that the web page level of interactivity is irrelevant. In reality, an interactive website is similar to a telephone or mail communications. A passive website is much the same as advertising on the radio or in the magazine. And an ad on the internet is no different than the ad in any other medium that provides a telephone number or other means of contact. It is merely an advertisement or solicitation of business, because of which the court held that the defendant had nothing more than advertise and solicit business in Illinois. That is, the court did not go into the determination of whether it's a passive, active, interactive site. It simply said that this company is using this website only as a means of advertisement. That conduct in itself was insufficient to give rise to personal jurisdiction.
Apna Course. Get smart, get ahead.